This Swanson Reed presentation provides information regarding the federal court case Commissioner of Taxation vs. Bakarich, which was handed down in December 2024. It's important to note that the material in this presentation is not tax or legal advice. The promoter penalty provisions which relate to this case are complex and serious. Where required, entities should seek dedicated advice from a legal professional on application of the promoter penalty provisions. Swanson Reed is an R&D tax agent and not a legal advisor. Commissioner of Taxation vs. Bakarich related to application of the promoter penalty laws, specifically for schemes related to tax offsets available under the R&D tax incentive. Promoter penalty laws are in place to deter the promotion of tax avoidance and tax evasion schemes. Swanson Reed welcomes and supports the work of Australian regulators in detecting and enforcing the promoter penalty laws. Maintaining integrity of the R&D tax incentive is important in order to maintain the program's sustainability. Under the promoter penalty laws, a scheme will be a tax exploitation scheme if, at the time of promotion, it has the sole or dominant purpose of an entity gaining a scheme benefit, and the scheme benefit would not legally be available or not reasonably arguable as being available. An entity will be a promoter of a tax exploitation scheme if it markets or encourages growth of the scheme, including schemes promoted but not implemented. It directly or indirectly receives a benefit in respect of marketing or encouragement. It causes another entity to be a promoter, or it has a substantial role in respect of marketing and promotion. Under the promoter penalty laws, the ATO can seek an order from the federal court that an entity pay a very large civil penalty, or it can seek an injunction from the federal court to restrain an entity from engaging in a particular conduct. The financial penalties are severe and would usually render entities found liable for them as commercially unviable due to their sheer magnitude. The applicable legislation for the promoter penalty laws is Division 290 of Schedule 1 to the Tax Administration Act, and the promoter penalty laws were originally introduced in 2006. Some exclusions apply to the promoter penalty laws, and they include employees or other entities that have only minor involvement, conduct that occurred by reasonable mistake or accident, something outside an entity's control and the entity took reasonable precautions to avoid it, or where more than 6 years have passed since the last relevant act of promotion or implementation, except in cases where there is tax evasion and no time limit applies. The ATO press release following the handing down of the Bakarich case stated the following: The Federal Court of Australia has handed down a judgment against Sydney business coach Julian Bakarich, his company co-director and former tax agent Taxation to Nguyen, and their related entities, the Dream Consortium P2 Ltd and the Dream Accountants P2 Ltd, ordering $13.6 million in penalties to be paid for breaches of the promoter penalty laws by promoting unlawful R&D tax schemes. Mr. Bakarich was ordered to personally pay a pecuniary penalty of $4.5 million, in addition to the $9 million penalties for the Dream Consortium and the Dream Accountants. Ms. Nguyen was also ordered to pay $100,000 for her role in promoting the R&D tax incentive schemes. A joint investigation between the ATO and the Department of Industry, Science and Resources found that between 2014 and 2017, Mr. Bakarich promoted unlawful tax schemes, encouraging clients to lodge overinflated, inaccurate, or unsubstantiated R&D tax claims. The ATO took action to seek penalties under the promoter penalty laws in relation to their conduct. Ms. Nguyen was deregistered as a tax agent by the Tax Practitioner Board in April 2019. ATO Assistant Commissioner Justin Dearness said this outcome should act as a strong warning to anyone considering promoting unlawful tax schemes and to those who knowingly lodge incorrect tax returns. Mr. Bakarich and Ms. Nguyen took advantage of clients who trusted them, and now, as a result, these individuals have had to face significant penalties. The ATO press release continues. The high penalties show not only the scale and abusive nature of their schemes, but how seriously we take unlawful promoter conduct. It serves as a clear warning to anyone tempted to promote or participate in tax schemes. You will be caught and held to account. The ATO's investigation identified approximately 138 taxpayers associated with suspicious R&D claims. ATO compliance action resulted in over $14.5 million in tax shortfalls, administrative penalties, and interest charges arising from identification of the promoter behaviour. The ATO is committed to protecting the integrity of the tax and super systems against those seeking to undermine it. We have the technical and investigative skills to deal with those who willingly and blatantly promote non-compliance with the tax and super systems. Through the Tax Avoidance Task Force, we're working to detect, deter, and disrupt the promotion and implementation of unlawful tax schemes. Promoting and participating in tax schemes are not victimless crimes. Those who engage in these behaviours are attempting to obtain an unfair advantage over those who do the right thing. Before you commit to tax advice, take a moment to think if it sounds too good to be true. You can also visit the ATO website to help spot the red flags of a tax scheme. If you are claiming a R&D tax offset, you must be able to provide evidence to substantiate your claims. The Bakarich matter is important for tax advisors involved with the R&D tax incentive for a number of reasons. There have been only a limited number of occasions where the promoter penalty laws have been applied, and a large proportion of these cases that have been handed down involve the R&D tax incentive. This includes the Lambda Chase and Australian R&D Fund and Grant Services matters published in recent years. In addition to this, the Bakarich case is now the most recently published case decided by a significant level of court, noting that the promoter penalty matters are handled by the federal court. It has also been handed down following a year of scrutiny on the tax advisor industry, which led to a number of changes in laws and regulations. Any advisor who offers or is considering offering R&D tax incentive services or who interacts with R&D tax advisors should familiarise themselves with this case. The case is published on the federal court website. The background of the case is that it involved 4 respondents, 2 individuals and 2 companies. The case found that there were contraventions of the Tax Administration Act on the part of each respondent by their conduct in promoting tax exploitation schemes that had the dominant purpose of obtaining R&D tax offsets for taxpayers where it was not reasonably arguable that those claims were available at law. The schemes related to R&D claims for various companies across the FY15 and FY16 periods. These contraventions were admitted by the individual respondents. In this presentation, we will highlight some key extracts from the judgment and then summarise what we feel may be the key takeaways. The judgment provides the following background information. Mr. Bakarich was the sole director, secretary and shareholder of the second respondent, the Dream Consortium, from the time of its incorporation to when he was declared a bankrupt. Mr. Bakarich had final responsibility for and control over the work of the Dream Consortium during the relevant period in which the tax or exploitation schemes occurred. In around December 2014, Mr. Bakarich and Miss Nguyen resolved that they would carry on a business together. In the course of their business, the respondents were involved in the provision of R&D services to clients, and a similar process was followed in the provision of these services in relation to each of the schemes. A prospective client was referred to the Dream Consortium by word of mouth or by a referral partner, or would contact the Dream Consortium after seeing its published marketing material which advertised R&D tax incentive services. A prospective client would attend an initial meeting to discuss the R&D tax incentive scheme with Mr. Bakarich and or other employees who would promote the Dream Consortium as R&D specialists with all the necessary approvals and accreditations and extensive experience in making R&D claims. They would discuss the possible benefits to the client of R&D tax incentives, ask general questions about the client's business operations, advise them that they were eligible, represent that the Dream Consortium could assist, and explain that the Dream Consortium would charge a fee based on a percentage of any R&D tax offset obtained. At the request of Mr. Bakarich or another Dream Consortium employee, the client would provide information about their business via an online questionnaire, including their operations and finances and how their company was being innovative in its business methods. This would be used by the Dream Consortium to prepare an R&D application and an R&D tax incentive schedule. The R&D incentive schedule was prepared by apportioning line items in the taxpayer's profit and loss statement according to an estimate of how much those items were devoted to R&D activities. As noted, the Commissioner alleges that Mr. Bakarich, the Dream Consortium, and the Dream Accountants contravened the Tax Administration Act in relation to the promotion of 12 tax exploitation schemes involving 11 taxpayers across the 2015 and 2016 financial years, and that Ms. Nguyen did so in relation to 3 taxpayers across the 2015 financial year. Mr. Bakarich and Ms. Nguyen admit these allegations. Mr. Bakarich also admitted that his conduct in respect of each of the schemes involved tax evasion. In general terms, tax evasion, as distinct from tax avoidance, is present when a scheme depends for its success on the Commissioner never discovering the true position. Applying that characterization to the schemes emphasizes the need to send a very strong message that engaging in promotion of schemes of this kind will not be tolerated. It has a statutory consequence in that by operation of the Tax Administration Act, the time limit for the commencement of proceedings by the Commissioner does not apply and does not need to be considered in this matter. Continuing on, the judgment notes that in relation to specific deterrence, while the Commissioner acknowledges that Mr. Bakarich has ceased the scheme promotion activities and has acknowledged liability, the admitted conduct reveals a culture at the entities which did not have regard to whether or not a client's claim for the R&D tax incentive was reasonably arguable. Some of these admissions include encouraging employees to maximise claims for the R&D tax incentive to secure higher commissions for the Dream Consortium, training employees to prepare Oz industry applications and pitch the business to new clients, and being dismissive of employees who raise concerns about the R&D claims. The following features of the contraventions contributed to the seriousness of the conduct. Mr. Bakarich accepts that his conduct was central to the creation, operation, and marketing of each of the 12 schemes, and that he was largely, if not solely, responsible for the conduct of the entities. He directly recruited scheme participants and provided assurances about their eligibility to claim the R&D tax incentive, and had significant control over the entity's employees who prepared and submitted Oz industry applications. Mr. Bakarich admits that his conduct involved tax evasion, and the parties submit that it did not involve any honest or reasonable mistake of law. There was a complete disregard as to whether or not a client's activities even qualified for the R&D tax incentive, and broadly, whether the claim for the R&D tax incentive was reasonably arguable. He recruited employees with limited or no work experience with R&D tax incentives and directly involved them in conduct which he admits involved tax evasion. There were multiple contraventions rather than a single contravention. The scale of the fraud on the revenue sought to be perpetrated was significant. As noted, the schemes would have produced refundable tax offsets of around $7 million had they gone undetected. Mr. Bakarich admits that he did not take any steps and did not cause any Dream Consortium or Dream Accountant employee to take steps to avoid any of the contraventions. After becoming aware in June 2016 that some R&D claims made by the Dream Consortium and the Dream Accountants clients were being investigated by the ATO, he did not take any steps to review the claims internally or cause clients to withdraw their claims. When an employee advised Mr. Bakarich that a particular claim under review should be withdrawn because it was unjustified, Mr. Bakarich instructed him to defend the claim. Further extracts from the ruling around the entity's internal processes noted, at different training sessions, Mr. Bakarich provided the following instructions to employees. An R&D grant is a grant in which the Australian government gives small and medium businesses a grant to help grow their business and reward them for being innovative. New knowledge means that the client is doing something that hasn't been done before, or they are having to experiment or try new things to succeed. It means at the end of the day, a new product, system or process will be developed and can be used moving forward. A project can range from a phone app or an innovative website platform to a new process of manufacturing. AusIndustry is the scientific body of the Australian government that approves the project. They work alongside the ATO. The eligibility part is self-assessed with AusIndustry. AusIndustry only care about the project. At the end of the day, AusIndustry just approve the project. You write the projects and submit them to AusIndustry. A client is eligible if they have the right entity size and setup, conducted R&D in the previous financial year, and spent over $20,000 in expenses doing so. Often the clients won't be aware that they will be eligible or were being innovative. It's the ATO that gives the money. AusIndustry don't care about the expenses. ATO doesn't care if it's innovative. They only care about whether the expenses are eligible. They are two different bodies, and your job will just be to prepare the project for AusIndustry. Then Miss Nguyen and her team will take it from there. Continuing on, extracts from the case note, during training sessions, Mr. Bakarich took employees through an AusIndustry application form and explained how it was to be filled out. Mr. Bakarich instructed them that you just need to take the answers that a client gives in their comprehensive questionnaire and then copy and paste them into the relevant box in the form. The questionnaire has been built around the form, so it should be quick. Then you just need to redraft some of the language to make it a bit more scientific or technical and stress the innovative aspects of the project. The better the client, the less time you'll need to spend on the form. During training, Mr. Bakarich explained how clients could claim R&D expenses, including by providing the following instructions. You get the client to send through the profit and loss statement, then go through with them and ask them what percentage of each of the line items was spent on R&D. That's their R&D claim. When you're going through their payroll, ask how much of their staff time was spent on R&D. With managers, directors and senior staff, you can claim more because managers are supposed to be out of the business and managing the team. They can claim a higher percentage of R&D, usually around 50 to 80%. This is because they're supervising the project and focusing on growing the team. Managers, CEOs and directors are expected to not be dealing with the day-to-day business, but spending their time focusing on expansion and innovation, so we can claim more for them. Sometimes you can claim 100% because all they're doing is R&D. Leaders and SMEs need to be focusing and innovating to survive. A lot of people don't realise what they're spending money on is R&D. It's up to us to tell them whether it's R&D. Of course, there are several problems with the instructions given here during the DREAM Consortium's training processes. Problems include a failure to mention the need to conduct a detailed assessment of a company's activities and aligning whether core R&D activities meet the specific definition in the tax law, and there was a failure to mention the need to conduct a detailed assessment of expenditure on any identified R&D activities, along with ensuring records of expenditure and staff time on these R&D activities exist. The ATOs simply do not allow estimation of time or costs as a basis for R&D claims, and the determination of employee time on R&D should not be determined by anything other than the company's evidence. Continuing on, the case notes, during the training, Mr. Bakarich taught employees about the expenses which clients could claim for R&D. This included management fees, which Mr. Bakarich said were nearly always claimable because the managers were always trying to be more innovative in the way that they operated their business and they developed the business ideas behind the R&D. Consultant costs, which Mr. Bakarich said were always claimable because consultants were focused on growing innovation within the business. On occasion, Mr. Bakarich would provide invoices to clients for his business coaching services as an R&D consultant. Mr. Bakarich said conference expenses were claimable because conferences were where innovation happened, and attending conferences tested the business and grew and trialed ideas with others. Mr. Bakarich also said that software subscriptions could be claimed if the project related to software or IT. The above training direction provided to the DREAM Consortium staff is not correct, particularly the direction given around management fees and consultant costs. Also, conference expenses and software subscriptions need to be assessed very carefully if they are to be considered for an R&D claim. Further extracts from the case judgment provide details around sales processes. This noted, employees attended client telephone calls and meetings with Mr. Bakarich. During those meetings, Mr. Bakarich had a typical sales pitch, during which he often said very similar things about the service the DREAM Consortium could provide, how R&D claims were prepared, and what expenses were eligible. The typical sales pitch employed by Mr. Bakarich included the following. The government has put $6 billion aside for innovation. They want to help small businesses innovate. The government is keen on growing innovation, especially for startups and small business. There is a pot of $6 billion that they can spend each year, but often don't get close because many people and businesses are unaware of the R&D scheme or are unaware that their business is innovating or undertaking R&D. It is an untapped resource that they can apply for. Small business can apply for funding and get it back from the government. It goes straight back in their pocket. The government wants to help them. It's very easy to access. It's an online, easy process. It's self-assessed and it's quick. This is the kind of thing that the government is throwing money at under the R&D grant program since the Australian automotive industry declined. They're keen to pay Australian businesses to be innovative and develop new products. You can claim for 3 years. In the first year it's development, the second is testing, and the third year is refinement. So, if you apply, you'll get 3 years worth of grants. We only need to estimate the costs and expenses to claim. The scheme is self-assessed. If you say you spent 20% of your time on something, who is the government to say otherwise? How much of your time did you spend on your project or innovating your business during the last financial year? And how much time did your employees spend? You can claim a general percentage of office overheads against all of the staff that spend time on the company's R&D project. You can claim my business coaching expenses as well because it's During our business coaching sessions, we are talking about how to develop your project, and that directly applies to your R&D. Did you travel for work or to attend conferences or any innovative seminars? If you're going to conferences and talking with people about your project, you can claim the cost of the conference and your travel and accommodation. Specialists can claim a higher amount. So if there is a specialized designer or R&D specialist, we can claim their whole salary because they're employed purely for R&D. They're doing something out of the ordinary. They're not just working in the business. Of course, there's a number of inaccuracies in the sales process highlighted above, and there seemed to be a failure to explain the risks and requirements of the R&D tax incentive to potential clients. Further extracts from the case ruling around internal claim preparation processes noted that from time to time, Mr. Bakarich questioned why certain expenses were not being claimed, and that he was the client's business coach and could, as such, answer questions on behalf of clients. Mr. Bakarich claimed that he knew the client and that there were additional expenses to be claimed. Mr. Bakarich asked for P&L statements and provided highlighted versions with items marked for claiming. When a new employee commenced at the Dream Consortium, several claims submitted previously were under audit. The employer reviewed the Oz Industry application and the R&D tax incentive schedule in respect of each of these claims and determined whether, and if so, how the audit could be defended. For many of the claims, he formed the view that the claim was indefensible because the client did not have a valid R&D project, the client had insufficient records to support their claim, heads of expenses they had claimed were ineligible, or the quantum of expenditure claimed was inflated. When the employee advised Mr. Bakarich that a claim should be withdrawn, Mr. Bakarich became very defensive and said that the Dream Consortium should do whatever they could to defend their claim. One reason Mr. Bakarich gave for defending claims was that the Dream Consortium would have to pay back its commission. An employee provided advice to a number of clients that it was likely that the ATO would refuse their claim and that they would have to pay the money back. Some clients had been paid money and thought it was unfair to pay the money back because they had been told it was a grant and did not appreciate that it was a self-assessment regime. On one occasion, Mr. Bakarich said to an employee that the R&D incentive is funding the business. It was paying everyone's wages. He noted that he had to pay salaries while the ATO was withholding refunds from clients and while they're under review or audit. Mr. Bakarich noted that unless the client gets paid, the Dream Consortium didn't get paid. He noted that you need to get them through the audit. We can't afford to pay the clients back. Of course, there are several issues highlighted here which seem to compromise the quality of the claims being prepared and pursued. To wrap up the extracts highlighted from the case, it was noted around engagement processes that the Dream Consortium's relationships with its clients were governed by terms and conditions appended to an initial online questionnaire. When clients completed and submitted the online questionnaire, they were required to accept the terms and conditions attached. The terms of the agreements included the fee payable by the client to the Dream Consortium in respect of their services. Mr. Bakarich was responsible for and was the final decision maker in respect of the fee arrangements between the Dream Consortium and clients. The R&D client fee agreements generally contained a term to the effect that the R&D clients would, once they had received their tax credit or refund, pay to the Dream Consortium a fee equal to 15% of the net financial benefit received by the R&D client as a result of their claim for the R&D tax incentive. There was also some further extracts in the case judgment stepping through the details of specific claims made, and these are worth reviewing for those that seek more information on the matter. In considering and applying the points raised in the judgment, key features that may have triggered application of the promoter penalty laws include sales processes which fail to explain risk or documentation requirements, misrepresentation of the R&D tax incentive as a grant rather than an R&D tax offset with tax obligations, providing staff with incorrect training and direction of how the R&D tax incentive operates, claims made based on maximising refunds rather than assessing legal eligibility of a company's activities and expenditure, claiming of expenditure that was known to not relate to experimental R&D activities, such as the inclusion of costs for business coaching, insufficient query or quality control processes for review of claims prior to lodgement, insufficient disclosure of regulated guidance from the ATO or Oz industry, or disclosure of legal requirements to clients prior to lodgement, failing to confirm that clients had supporting documentation to evidence their claims prior to submission, and broad brush apportionment or arbitrary calculations that don't consider the nature of expenditure or supporting documents, such as records of employee R&D hours. For tax advisors involved with the R&D tax incentive, key steps to minimise risk and to maintain integrity may include only provide R&D tax services where professionals providing them are suitably qualified in the intricacies of the R&D tax legislation. Establish a culture that seeks to prepare claims only within the letter and spirit of the R&D tax law. Seek to ensure claims are made in accordance with regulated guidelines published by the ATO and Oz industry. Ensure companies understand that R&D tax claims are a self-assessment tax lodgement based on activity actually performed and expenditure actually incurred and, where required, paid. Specifically, companies must understand that R&D tax incentive claims are not a grant from the government for their future activity, but rather are a legislated entitlement based on expenditure incurred if they meet a specific criteria and can evidence compliance with the relevant laws. Advisors should make claimants aware of their legal requirements to substantiate claims in the event of a review and confirm that they have suitable supporting documentation. Should also ensure that R&D activity descriptions are factually correct and supported by documentation around the nature of the activity. R&D firms should provide training to staff on the correct application of the R&D tax laws. This involves assessing activities and delineating between core, supporting, and non-R&D activities carefully, ensuring core R&D activities are assessed in detail for new knowledge and unknown outcome requirements, assess R&D expenditure, including the need to substantiate employee hours and apply rigor over R&D apportionments, and also to apply R&D tax integrity rules such as the clawback mechanisms. It's also important that advisors constructively engage and cooperate with regulators where they're required to do so. Changes to the promoter penalty laws have also recently been made and apply from 1 July 2024. These changes include extending the time limitation for the ATO to commence civil proceedings from 4 years to 6 years, increasing the maximum penalties the federal court can impose, changing the requirement that a promoter receive consideration to the promoter receiving a benefit, which can include benefits received that are less obvious, intangible, disguised, or non-quantifiable, extending the meaning of a tax exploitation scheme, extending the scope of promoter penalty laws to apply to all ATO rulings rather than only product rulings, and expanding the scope of prohibited conduct. That concludes our update on the federal court matter, Commissioner of Taxation versus Bakarich. We stress that it's important that all stakeholders, including claimants, advisors, and regulators, play a role in maintaining the integrity of the R&D tax system to contribute to it being sustainable. Swanson Reed supports the important work done by the ATO, AusIndustry, and other government agencies in this regard. Also, a reminder that the material in this presentation is not tax or legal advice. The promoter penalty provisions, which relate to this case, are complex and serious. Where required, entities should seek dedicated advice from a legal professional on application of the promoter penalty provisions. Swanson Reed is an R&D tax agent and not a legal advisor. Please see the ATO or Swanson Reed website for additional information. Or alternatively, please contact our office if you would like to discuss. Thank you for listening to this presentation.